Laughed first. That's what I remember most. Not the papers, not the look on her attorney's face, not even the moment everything fell apart for her side. I remember the laugh. Short, sharp, like she'd just heard the punchline to a joke only she understood. She leaned over to her lawyer and said something I couldn't hear. He smiled too. And the woman sitting beside my ex-wife, some associate, younger, holding a stack of folders, she covered her mouth like she was trying not to join in. I was standing at the respondent's table, alone, no briefcase, no suit jacket that actually fit right. Just a manila folder, a USB drive, and the kind of stillness you develop when you've already accepted that things are going to get worse before they get better. The judge looked at me over his glasses and said, "You understand you have the right to counsel?" I said yes. He said, "And you're choosing to proceed without representation?" I said yes again. That's when my wife laughed. I need to back up, because none of this makes sense without the 18 months that came before it. My wife and I met when I was 26, she was 29. I was working IT infrastructure for a mid-sized logistics company, and she was running the operations side of her family's freight brokerage, a business her father had built from nothing and handed to her when his health started going. Her name was Vivian. Her family called her Viv. I called her that too, for a while. Toward the end, I didn't call her much of anything. We got married after 2 years together. It felt right. She was driven and I was steady, and for a while, that combination worked. I kept the house running. She kept the business growing. We didn't have kids. We had a plan. Travel. Savings. Maybe a property outside the city. Normal things. Good things. I won't pretend the marriage was perfect. It wasn't. But I also won't pretend I saw what was coming, because I didn't. The first sign was small. I noticed it about 3 years in. There was a home equity line of credit on our joint account that I hadn't known about. When I asked about it, she said it was for business cash flow. Short term, already repaid. The paperwork confirmed it, more or less. I let it go. The second sign was harder to dismiss. About 8 months later, I was looking through our tax returns. I do our taxes, always have, and there were deductions I didn't recognize. Business expenses claimed against our joint income. Vehicles, equipment, a consulting fee paid to a company I'd never heard of. When I asked, she said her accountant handled it, that it was standard practice for a business owner filing jointly with a spouse. I'm not a CPA. I accepted that. The third sign I almost missed entirely. It was a Tuesday night in November. I was updating our household budget spreadsheet, something I kept obsessively, the kind of thing my wife used to tease me about. And I noticed that a recurring transfer from our savings account had changed. Same destination, same frequency, but the amount had increased. By a lot. I stared at it for a long time. Then I closed the laptop and went to bed, and I lay there telling myself there was probably an explanation. There wasn't. By the time I figured out what was actually happening, it was the spring of the following year, and by then, she had already spoken to a divorce attorney. I found out because the attorney sent a letter to our house. She'd forgotten I worked from home on Fridays. What Vivian had been doing, what I eventually pieced together over about 4 months of careful, quiet documentation, was this: she had been systematically underreporting the value of the freight brokerage by routing revenue through a subsidiary company she'd created 3 years into our marriage. The subsidiary had a different name, a different address, a different EIN, but the same ownership structure, her. The money that moved through that subsidiary didn't appear on the brokerage's books. It appeared as operational expenses on invoices that went nowhere real. By the time she filed for divorce, she had been able to present a valuation of the brokerage that was roughly a third of what it actually generated. The reason this mattered: Georgia is an equitable distribution state. Marital assets, including appreciation in a business acquired before marriage but grown during it, are subject to division. If the brokerage looked worth $800,000 on paper, I get a fraction of that. If it was actually worth $2.5 million, the picture was very different. She also had control of our joint investment accounts, which she had moved into her name alone about 6 weeks before filing. She said it was for estate planning purposes. The transfers happened on a Friday. I did not have a lawyer. I couldn't afford one. Not a good one. Not for a case this complicated. The attorneys I consulted wanted $10,000 to $15,000 up front before they'd touch the financial forensics. I didn't have that. Not liquid. Not fast. So I decided to do it myself. I want to be honest about what that decision felt like. It didn't feel brave. It felt like standing at the edge of something I couldn't see the bottom of and choosing to step off anyway because I didn't have another option. I spent 3 months reading case law. I watched depositions on YouTube. I joined a forum for pro se litigants that was mostly sad and occasionally useful. I read the Georgia Code until I could cite it in my sleep. I also built a file, not just documents. A structured, sourced, time-stamped file of everything I had found. Bank transfers with dates and amounts. Corporate registration records for the subsidiary. Invoices that didn't match any real vendor I could locate. A forensic accounting report I'd commissioned from a CPA I found through a small business association. It cost me $2,200 and I paid it on a credit card and I would do it again 100 times. I also had something she didn't know about. 3 years earlier, when we'd upgraded our home network, I had set up logging on our router. Not for any suspicious reason. I'm in IT. It's just what I do. I wanted to track bandwidth, diagnose slowdowns, monitor devices. The logs had been running continuously since then, and those logs showed, among other things, the timestamps of activity on her work laptop when it was connected to our home network. Activity that corresponded, almost exactly, to the times the suspect transfers were initiated and the fraudulent invoices were created. I hadn't planned to use them. I didn't know I'd need them. Until the day I walked into Fulton County Superior Court without a lawyer and my wife left. The judge's name was the Honorable Gerald Ashby. He had been on the bench for over 20 years. He had the kind of face that gave nothing away. Not impatience, not sympathy, nothing. He ran his courtroom the way a good ER runs, efficiently, without drama, in strict order of priority. Her attorney was a man named Preston Caldwell. He was the kind of lawyer who wore his reputation like a second suit. He had a quiet confidence that came from winning often enough that losing felt theoretical. His associate, the young woman who'd smiled, was there to carry the folders and take notes. The opening was straightforward. Vivian's side laid out their position. The brokerage was hers, built on her family's legacy, worth what their valuation said it was worth. The joint accounts had been transferred for legitimate estate planning. There were no marital assets beyond the house, 2 vehicles, and a retirement account. They were calm, organized. They presented like people who had done this before and expected it to end quickly. Then it was my turn. I stood up. I said, "Your Honor, I'd like to submit evidence that the valuation presented by the respondent does not reflect the actual financial performance of Hollow Freight Systems, and that marital assets have been deliberately concealed and moved in anticipation of these proceedings." Caldwell objected. Foundation. Relevance. The usual. Judge Ashby looked at me. "Do you have documentation to support these assertions?" I said, "Yes, Your Honor. Quite a bit of it. I had organized everything into tabbed binders. 3 copies, 1 for the judge, 1 for opposing counsel, 1 for me. I handed them to the bailiff. The room didn't freeze exactly. But something shifted. Caldwell opened his copy, and I watched his eyes move across the first page. Then he turned to the second. Then he stopped moving entirely for a moment. Vivian was watching him. She saw him stop, and I saw her see it. That was the moment her smile went away. The hearing ran across 2 days. On the first day, I walked through the documentary evidence, the forensic accounting report, the subsidiary's corporate filings, which I had pulled from the Georgia Secretary of State's database, public record, free, available to anyone who knows to look. The invoice trail that led to vendors who either didn't exist or had no record of doing business with the brokerage. Caldwell cross-examined me. He was good at it. He tried to establish that I had no financial expertise, that the accounting report was biased because I'd commissioned it, that I was misinterpreting standard business practices. I had anticipated every one of those arguments. I had read enough case law to know they were coming, and for each one, I had a response in my binder, tabbed, and cited. At one point, he asked me, "You're a network engineer, correct? Not an accountant?" I said, "That's correct." He said, "So your interpretation of these financial records is based on what exactly?" I said, "My interpretation is based on the report prepared by a licensed forensic CPA, which is in your tab C, along with her credentials and methodology. My own expertise is relevant to a different section of the evidence." He paused. "And what section is that?" I said. "Tab F, Your Honor." Tab F was the router logs. I spent about 40 minutes explaining them to the court. I prepared a visual summary. A simple table, printed clearly, that showed dates, times, and IP activity on my home network. I correlated each entry with the corresponding financial transaction from the brokerage's records. I want to be careful about how I describe what happened next because it wasn't dramatic the way courtroom scenes in movies are dramatic. There was no gasp. No one stood up. Judge Ashby simply asked several very precise questions, and I answered them. And then he asked Caldwell if his client wished to respond to the correlation I had presented. Caldwell asked for a recess. During the recess, I sat alone at my table. I drank water from a plastic bottle. My hands were steady. I had expected them to shake. When proceedings resumed, Caldwell made a motion to exclude the router logs on privacy grounds. He argued that monitoring network activity in a shared residence raised evidentiary concerns. Judge Ashby denied the motion. He noted that the network was owned and maintained by the respondent, me, and that no expectation of privacy had been established for activity on a jointly used home network. Vivian said something to Caldwell. I couldn't hear it. He responded without looking at her. The second day was different. Caldwell was still professional, but the quality of his engagement had changed. He wasn't pushing the same pressure. He was recalibrating. I called one witness, the forensic CPA who had prepared my report. Her name was Dr. Sandra Okafor. She had 22 years of experience and had testified in commercial fraud cases at both the state and federal level. She was calm, precise, and utterly unmovable on cross-examination. When Caldwell tried to challenge her methodology, she walked him through it, step by step, in a tone that was polite and slightly devastating. After her testimony, there was another recess. This one lasted longer. When Caldwell returned, he approached the bench. He said he needed to make a disclosure to the court. He said that in reviewing the evidence submitted by the respondent, he had identified information he had not been made aware of by his client. He said that continuing to represent her without that information having been disclosed to him created an ethical concern he was not able to ignore. He said he was withdrawing as counsel, effective immediately. The room was quiet. Vivian sat at the table alone. Her associate gathered her folders and left without making eye contact with anyone. Judge Ashby looked at my ex-wife for a long moment. Then he looked at me. Then he said the hearing would be continued to allow her to obtain new counsel, but that the evidence submitted by the respondent would remain in the record. She didn't get new counsel. What she got, about 6 weeks later, was a call from the Georgia Secretary of State's office, and then from the IRS, and then, eventually, from a federal prosecutor's office, because the subsidiary arrangement had implications that went beyond civil divorce proceedings. I want to be clear, I didn't report her. I submitted evidence to a civil court. What followed from that? The investigations, the separate proceedings, those happened because the evidence was part of the public record and because other parties, with more authority than me, decided to act on it. The civil case resolved first. Judge Ashby awarded me 40% of the assessed marital value of the brokerage, calculated using Dr. Okafor's methodology rather than Vivian's submitted valuation. He also ordered the reversal of the joint account transfers and awarded me attorney's fees, pro se fees, a smaller amount but meaningful, on the grounds that the other side's conduct had unnecessarily complicated proceedings. I walked out of that courthouse on a Tuesday afternoon in March. It was cold. I sat in my car in the parking garage for a while and didn't do anything. Just sat. I had won. I knew that. But it didn't feel the way I thought it would. It felt like being very tired and very relieved and a little bit sad. Not for her, not exactly, but for the version of things I had believed in for a long time. People ask me sometimes, usually online, in comments or forums, whether I regret representing myself, whether I would do it differently. The honest answer is, I would do it the same way, but I would start earlier. I spent 8 months documenting before I set foot in that courtroom. 8 months of evenings and weekends and early mornings, reading and filing and building the case quietly while the rest of my life continued on the surface. If I had started from the moment I saw that first equity line I didn't recognize, if I had trusted the thing that felt wrong instead of explaining it away, I would have had a stronger position even sooner. What I learned is that preparation is not the same thing as intelligence. I'm not particularly brilliant. I don't have a legal background. I have an IT certification and a stubbornness that my mother used to call a character flaw and that I have since reframed as a professional skill. What I had, more than anything, was records. I kept records of everything, not because I suspected anything at first. Because I'm the kind of person who keeps records. The router logs were running because I set them up in 2021 and never turned them off. The budget spreadsheet existed because I find it calming to know where our money is. The corporate filings were public record because I happen to know that you can search them online. I didn't have a plan, I had habits. And the habits saved me. There is one more thing I want to say. There were other people affected by what Vivienne had done. Not just me. The brokerage had employees, 7 of them, whose pension contributions had been shorted over a period of about 2 years as part of the cash management strategy she'd been running. Those 7 people didn't know. They were just working, trusting that the numbers were right. Part of what I submitted to the court included the pension records, not because it helped my divorce case directly, because it was the right thing to submit. When the settlement was finalized and the investigations were underway, those employees' accounts were made whole through a process I wasn't directly part of, but was glad to know was happening. That mattered to me more than the money. I'm not saying that to sound noble. I'm saying it because it's true, and because it was the only part of the whole experience that felt clean and uncomplicated. The part where something broken got fixed for people who hadn't done anything wrong. The rest of it, the marriage, the betrayal, the 18 months of documents and legal research and sitting alone at a table while my ex-wife's attorney withdrew from her case, that was messy and exhausting and not something I would wish on anyone. But I did it, without a lawyer, without money, without anyone in that courtroom who believed, when I stood up, that I had any idea what I was doing. She laughed first. She stopped laughing on the second day when her own attorney stood up and walked away from her. And I sat at that table, alone, and kept going. I thought a lot about what actually happened in that courtroom. Not the legal outcome. I understood that part well enough by the time Judge Ashby read his ruling. I mean what happened underneath it. The mechanism of it. Why things ended the way they did. Vivienne didn't lose because I was clever. She lost because of what she had done, and because she had done it long enough that the evidence was everywhere. In bank records, in corporate filings, in router logs that had been quietly running for 3 years on a home network she thought belonged to both of us. Every action she had taken to gain more left a trail, and every shortcut she took, every invoice that went nowhere, every transfer times to a Friday afternoon, every pension contribution that came up short, those weren't mistakes. They were choices, and choices may consistently over time become a record. That's not fate. That's not luck. That's just how cause and effect works when you stop paying attention to it. I think about the version of me who explained away the first equity line, the version who accepted my accountant handles it without asking another question. I was not dishonest, but I was willing to be comfortable instead of clear-eyed, and comfort cost me years I can't get back. I don't blame myself for that the way I used to, but I do take it seriously. There is a kind of intelligence that isn't about IQ or credentials. It's about staying honest with what you're actually seeing, even when what you're seeing is inconvenient. I didn't have enough of that early on. I have more of it now. What I had when it mattered most was the willingness to do the unglamorous work. 8 months of evenings, legal forums, case citations, a $2,200 accounting report on a credit card, tabs, binders, a table in my own handwriting correlating timestamps to transactions. None of that was brilliant. All of it was deliberate. Persistence isn't a talent. It's a decision you make again every morning, including the mornings when you're exhausted and the other side has a $400 an hour attorney and you have a folder and a USB drive. Preston Caldwell withdrawing from that case mid-hearing, I don't think about that moment as a victory over him. He did the right thing, actually. When the evidence made his client's conduct undeniable, he chose his professional ethics over his client's interests. That takes something. The person I think about is not him. It's the 7 employees whose pension accounts were short. People who came to work every day and trusted that the numbers were being handled honestly. They weren't part of my divorce case, but they were part of what was wrong, and I wasn't going to walk past that just because it was easier to leave it alone. I'm not sure what to call that impulse. It's not heroism. It's too ordinary for that word. It's closer to the feeling you get when you see something broken that you have the ability to fix, and you know that choosing not to fix it is still a choice. I had the records. I submitted them. Other people with more authority than me did the rest. The marriage ended. The case resolved. I sat in a parking garage in March and felt tired and relieved and a little bit empty all at once. That's how most real endings feel. Not like a movie, not like a speech, just like something that is finally, quietly over. What I carried out of it was simpler than I expected. Keep records. Trust what you're seeing. Do the work even when no one is watching. And when you have the chance to do right by people who didn't do anything wrong, take it. Not because someone is keeping score. Because you are.